Good morning, Your Honors, and may it please the Court. My name is Joe White. I'm from Cumberland County, Tennessee. I'm part of the Cumberland County Bar. I'm here today on behalf of the appellant, my client, Mr. Thomas Mack Arnold. There's two issues, Your Honors, that I have highlighted for your appeal today. The first issue is whether the evidence was sufficient to sustain the holding of first-degree murder. Specifically, whether my client, Mr. Arnold, had the premeditation required in their finding. And then the second issue that I'm going to cover today is whether the prosecutor's comment and closing statement constituted prosecutorial misconduct when he mischaracterized and misstated what my clients said. First, Your Honors, I had covered the Reynolds case in this, State versus Reynolds. There's a list of factors in there, and as General Ward stated in his response to me, they're not exhaustive, and some, in my understanding, can be used with more or less weight, depending on how the jury sees it. I went through all the factors, and from my analysis of the case, I only found that one weighed in favor of the state, and that is that no aid was rendered. That's part of the test in the Reynolds case. But for today's purposes, I'm not going to go through every single one of them. I can't. I don't have time.
So what did if you recall, what did the state argue to the jury was premeditation?
Well, and this will require a little bit of speculation. I was not trial counsel, so.
And if you don't feel comfortable saying it, it's okay. I just was, if you had a recollection.
Okay. And moving back, Your Honor, to answer your question, is it okay if I give like kind of a basis of the outline of facts, and then it could
Sure. I
make
don't want to
sense.
take away from your argument, but
Yes, sir.
if you want to.
No, Your Honor. So essentially in this case, it accumulated all on September 27, 2020. There's a home, to me it looks like a manufactured type home, maybe a mobile home, in rural Cumberland County, Tennessee, near the Bledsoe County line. There's a lot of people there, and they're meeting up for this event called the Gambler. Now the Gambler is like a car show of sorts, and they all wanted to go to it. Everyone there, including the victim, Bill Jones, was using drugs. He was using meth. I guess it could be referred to kind of like a trap house. Okay, so there's people coming in and out. There's drugs being used. So you got Bill Jones, the victim in this case. You've got Bill Jones married to a woman. There's a Mary Ann Crane, who's also Bill Jones. That caused some strife between the wife and Bill Jones, of course. And then you have Amy Arnold. Amy Arnold is the estranged wife of my client, Tommy Arnold. Amy has a camper out there on the property. This camper, for some reason, is being moved. I don't know. It makes Amy very upset. Amy fires a shot. Somewhere along the way, this is like days leading up to it. And then communications had between Amy and her estranged husband, my client, Mr. Arnold. She says, I want Tommy to beat up this Bill Jones for messing with my trailer. And Tommy says, okay. He's like, that's what we'll do. Okay, and then what happened after that is very hard to decipher, because you have, and I'm not trying to reweigh anything here, Your Honors.
Well, that's what I was just going to ask. I mean, yes, the facts seem to be pretty much all over the place, as you might expect under the circumstances that you described of what was going on at the house. But the jury heard all those witnesses, and they weighed the credibility with all the other evidence, didn't they? I mean, I don't know how we can get to what you're asking us to do without reweighing the evidence.
Correct, but some of it just doesn't make logical or jurisprudential sense. And a couple of these elements, like element 4, procurement of a weapon, do not, according to what was weighed at trial.
And again, weren't there some witnesses that said, yeah, the victim had a weapon, and some said they didn't? And
there was only one that said he had a weapon, and that was the victim's brother, Bill Jones, who also stated that there was no knife and other contradicting things. Okay, I understand the jury saw that, and they ruled on that. However, procurement of a weapon, there were two witnesses. One, disinterested high school kid across the street who saw Tommy go into the trailer, with a backpack on. Well, Bill Jones died from a single gunshot wound, a slug-type gunshot wound. That comes from a shotgun. So, and then in all counts, everyone said the shooting was very much chaotic, and it was just like that. That's what the first witness, Jason Boyko, said. He said it's chaotic and quick. So, how does it make any kind of logical sense that these two witnesses who see him go in and go, well, I'm not sure if the kid saw him, but at least go in and come out. Branson Eldridge is the other witness I'm talking about here. But the kid says he sees Tommy Arnold go into the house. My client has a backpack on. How is he fitting a shotgun, even if it's sawed off, in the midst of all this chaos, stuffing it back into his backpack, and has the wherewithal within seconds in a chaotic situation to get out of there and no one sees a gun or anything? That it doesn't make sense, Your Honor. And I know the jury ruled on what they ruled, but that's why I'm saying it's irrational for any trier of fact, even with the increased burden of proof, which is, well, my client is now presumed guilty. I understand that. It still doesn't make any sense.
Is it disputed that he had a clown mask on? Is that?
Yes, sir. Yes, Your Honor, it is. I apologize. Yes, Your Honor. It is disputed. So Jason Boyko, he's the first witness in all this. And Jason Boyko said, 1, he was high. 2, he couldn't hardly see. 3, somebody came in wearing a crazy clown mask, and it was chaotic and quick, and he got out of there. Well, Jason Boyko, and again, I'm not trying to discredit him or anything. Identity theft charges. This is the state's key witness, their first leading witness, saying that he sees a clown mask. He's the only one that said he saw a clown mask.
No clown mask was found and put into evidence.
No, Your Honor, it was not. And then I think telling too is that high school kid across the road, when he sees Tommy Arnold come out, he's not wearing a clown mask. This happened in September. Halloween is plenty far off. That would have been very striking and unusual. Bill Jones's brother, who, again, none of these witnesses agree on hardly anything except that Bill Jones was shot. And that's about that. Bill Jones's brother, however, he said that there was a bandana, or they're the only two ones that I know of that said anything about a masked intruder or shooter. As it gets back to the procurement of the weapon, there was evidence presented that the same type of weapon was found at the scene that the victim, Bill Jones, had before. Bill Jones had sold somebody, well, Mr. Jackie Martin, it's in the transcript, but he had sold somebody a shotgun for drugs and maybe some cash. And then Miss Hurd, when she testified, she said, yeah, I not only saw the shotgun, it was leaning right up against that recliner. And it's like, it gets to the whole intent of what Tommy Arnold wanted to do that day. I do not think, looking at this, and again, I didn't try the case, but I think that helps because I can objectively look at the facts. I know he's my client, but these facts tend to indicate that Tommy Arnold went in there to confront Bill Jones. And when he confronted Bill Jones, he was met by a very drunk and very high Bill Jones, who, at that point, no one knows what happened. There's different people saying different things. Jason Boyko, the first witness, said that they're struggling over a weapon. Mary Crane's statement got in there, even though it was just hearsay. Well, she had told Mr. Boyko that the victim, Bill Jones, had plunged at my client with a knife. And all of those things together make me believe that shotgun was already there. And if that shotgun was already there, how could Tommy Arnold have developed any kind of intent to not only have the depraved heart to kill a man, but he couldn't. The situation would have had to have worked out perfectly. I think he went in there. I think Bill Jones was armed. However, the jury came up with what they came up with. I just think, Your Honors, it is unreasonable and irrational that they did so, especially with the logical, inexplanations, I would say. I don't want to run out of time here. The next one I went through was what the prosecutor said in his closing argument. And to kind of preface this a little bit, I quoted Wainwright that the relevant question and what we're determining today is whether his comments so infected the trial with unfairness as to make the resulting conviction a denial of due process. And it was. It was because what the prosecutor, General Hatch, in this trial said was, he said, and when he says he's referring to my client, he said that I shot Bill Jones because he charged me with a knife. My client did not say that. And what they were referring to was the Georgia officer's testimony that when he picked my client up in Georgia, and my client did, he left the state of Tennessee, they picked him up in Cordell, Georgia, and when he was speaking to that officer, and this was tried to in a suppression hearing, but he said, this is that stuff out of Tennessee, and then he said 3 words, self-defense shit. That's what he said. However, the prosecutor rephrased all of that to say that Tommy Arnold said, I shot him. Well, Tommy Arnold did not say that.
Okay, so walk us through what actually happened at trial when the prosecutor made that statement. I think there was an objection.
There was. The trial counsel, Mr. Robert Marlowe, he's a great attorney. He did object to that. He objected right when it happened, and that's not common in any trials that I've seen. It's generally closing statements are unobjected. So when he did, it seemed to have, and of course I'm reading the transcript here, it seemed to have shocked the judge. He said, what are you objecting to? That statement. And then once that statement was made, they said, well, jury, what they say is not evidence.
Yeah, so the judge gave a curative instruction.
That's not near curative enough, Your Honor. And
Well, after the curative instruction was made, was there any further objection or request for a mistrial?
there wasn't, no, and that was brought up in General Ward's brief. And in that situation, in a trial, when you've lodged an objection, the only thing that can result from any further objecting or arguing with the judge is you're going to make the judge mad. And I'm sure, and two, I don't think that's a standard anyway. Now, I think rephrasing and self-admitting for somebody is enough to meet the plain error standard, but I think the contemporaneous objection to the statement itself gets us to where we analyze these factors for prosecutorial misconduct.
So after the trial judge gave the curative instruction, what did the prosecutor do? Was there
He marched onward, as far as I can tell,
didn't
Your
correct
Honor.
his statement or didn't say anything further, he just stopped and went on?
Yeah, right. He kind of continued, didn't say, look, I'm sorry, that's not what he said. There was never clarification on that, and I think that Your Honors, is the main problem here. And really, I think the jury was irrational with their verdict, but this is an issue that I think wins the day for the appellate. And the reason is, okay, Mr. Arnold, he invokes his constitutional right not to get up there and testify. So the prosecutor, when he gets up there, it says, he said, I shot Bill Jones. The prosecutor, one, has no source for that, and two, he's making an admission through my client who did not testify. Now, if they wanted to use what they had, if they wanted to use whatever the jury was presented, which was that police stop in Cordell, Georgia, then sure, go ahead and do that. But by phrasing it in that way, he basically admitted to the shooting for the client when my client never admitted to it. He never said I shot Bill Jones. So when looking at the Wainwright elements in that, so conduct complained of in view to the context, this is a first-degree murder trial. Due process protections, in my opinion, Your Honors, is at the highest level it could be at. There's a lot on the line here. Well, he got a life sentence. And so in light of the facts and circumstances of the case, yes, these are very applicable. Any curative measures? Well, that gets us to the trial court's comment that, hey, what he says is not is not evidence.
Let me ask a question. Did the defendant argued self-defense? Or was that, it appeared to me, was self-defense instructed?
I don't know, Your Honor.
Okay.
And I apologize. I don't know.
Well,
I know.
I guess I'm trying to get to if the defendant, I know he didn't testify, but if it was argued that it was self-defense and, you know, a statement was made and argued by the prosecution that he shot him in self-defense, how does that actually hurt if that was his theory? What's the prejudice?
Well, I think it's the former part of the sentence. I shot Bill Jones. That is, in a murder case, that is a direct admission.
Were they arguing that he didn't shoot Bill Jones?
And in a lot of ways, it seemed that Mr. Marlowe did argue that.
Okay.
That he had argued that, well, there's no ID, and he went through a burden of proof argument, in my opinion,
Sure,
more so.
To me, I'm thinking, well, if they're trying to argue self-defense, then they're not arguing that he didn't shoot him. And I don't know, I haven't done a deep dive into the record, so that's why I'm asking the question.
Right, Your Honor, and that was, it was maybe a little bit of self-defense, and I didn't look at the instructions, and I apologize for
That's
that.
okay.
One of the Wainwright elements looks at the intent of the prosecutor in making the statement. He's trying to win his case. I mean, do I blame General Hatch? No. Do I think he's malicious? No. However, the statement itself was beyond the scope of what he was allowed to do. So that has to be called upon. The cumulative effect of the improper conduct. A prosecutor, especially in a small rural town like Cumberland County, Tennessee, is the highest of the law enforcement food chain. In my town, law enforcement is very respected. I respect them myself. He is, even as an assistant district attorney, you know, like the chief law enforcement officer up there. So when he says something, people will listen. And the cumulative effect of that, I think, is swayed the jury into the state's favor improperly with facts that weren't in evidence. And then the relative strength and weakness of the case. It's very important to state here that the case's lead investigator, Stephen Webb, said, and I quote, there wasn't a lot to work with here, and we've interviewed minimal witnesses. That is a bizarre thing for a lead investigator to say. I think that speaks right to the weakness of this case. And, Your Honors, if there are no questions, I would ask to reserve 2 minutes of my time.
Let me just ask one question.
Yes, sir.
The self-defense came up through Officer Telfair or something like that, the Georgia officer. Did it come up through other witnesses too?
Not really that I know of, Your Honor.
Yeah.
Thank you, Your Honors.
Thank you.
Morning, Your Honors. May it please the Court. Garrett Ward on behalf of the State of Tennessee. Your Honors, this Court must affirm Mr. Thomas Arnold's conviction for first-degree murder because it is supported by sufficient evidence and because the defendant's closing argument complaint is non-meritorious. Dealing first with sufficiency, really, Your Honors, this Court's inquiry, as has been presented to it by the defendant, is limited to premeditation. I don't see him presenting before this Court any challenge to any other element of first-degree murder. I'm happy to discuss them, but I'll limit my discussion before this Court, as I did in my brief, to premeditation. And as is often the case, Your Honors, indeed, as is probably the case more often than not, premeditation here is derived from circumstance. This isn't a case where we have, a notebook from the defendant saying, I plan to kill Bill Jones. What we do have is this interesting little almost jigsaw puzzle of circumstantial evidence that the jury could view in a certain way and make a premeditation finding, and that's precisely what the jury did here. Really, I'd say the centerpiece of the state's case for premeditation is a series of text messages exchanged between the defendant and his wife, and some text messages between the wife and her son. And what these text messages show is that roughly an hour to an hour and a half before there is a shooting, before the shooting in this case, that Mr. Arnold's wife texts her son and says, I need you to get a hold of the defendant because I need him to go and beat the brakes off of the victim. About 20 minutes after that, the defendant's wife texts him and says, "I need you to get here as soon as possible." And about a half hour, 40 minutes after that text, the defendant responds to his wife and essentially says, "Calm down, we're good, I'm on my way, I love you, I'm bringing my slingshot." So, Your Honors, what these text messages, what they really show, what the jury could rather easily derive from these text messages, is that Mr. Arnold's wife wanted him to commit violence on Bill Jones, and that Mr. Arnold wanted to let his wife know he was down to do that, and that he was coming armed with a weapon. Then we have eyewitness testimony from people outside the house and people inside the house. I'll discuss the sort of exterior witnesses first. What these witnesses tell us, and there's a defense witness and a state witness that largely tell the same story about Mr. Arnold's arrival on the scene, is that he arrives on the scene, that he gets out of a car, he's traveled there with his wife, he gets out of a car, he walks around to the back side of this house at 25 Christian Road, presumably goes inside at this point. He's out of the eyesight of these witnesses. That he walks around the back side of the house, that they hear a single gunshot. He's carrying a backpack, and that after that gunshot is heard, they see him come back around the back side of the house, walk in the car, and leave.
Did anyone say they saw him with a shotgun?
Not precisely, Judge Holloway. What the witnesses on the outside said he had some sort of backpack or satchel, and then the witnesses inside do affirmatively testify they see him with a shotgun, or they see a man with a shotgun. But at that point, there's some sort of mask or facial covering. The testimony is a little muddy on what precisely it was. So the interior witnesses, they see a man with a shotgun, but his face is covered. So they can't affirmatively say that man is Mr. Arnold. The exterior witnesses affirmatively see Mr. Arnold, but he's carrying a backpack at the time.
Did they recover the shotgun and introduce it into evidence?
The shotgun itself, no. There was evidence of shotgun usage that was documented at the scene. I believe it's a jacket and wadding, and then the nature of the wound and some damage to a wall in the house do demonstrate that a shotgun was used, but no, the actual weapon was not found. So these exterior witnesses sort of describe to the jury Mr. Arnold's path into and out of the house. Witnesses inside the house say they see this man with his face covered get into an argument with Bill Jones, that at some point the men break apart. And that when they break apart, Bill Jones says, "Well, go on, shoot me." And that the man with the facial covering, at that point, he takes out the shotgun and shoots Bill Jones in the chest. Your Honors, from these pieces of evidence, from the text messages, from the exterior witnesses, from the interior witnesses, the jury can rather readily conclude that Mr. Arnold acted with premeditation. They hear him, or they can see the text message where he's talking to his wife. "I'm coming, and I'm coming with a weapon." They can hear the testimony of the exterior witnesses that say he goes into the house, we hear a single shot, and he immediately leaves. He walks in, hear one shot almost immediately, and he immediately leaves. These interior witnesses say that that they break apart, the victim says, "Go ahead and shoot me," and that he does. Your Honors, this is a case that, viewing the evidence in the light most favorable to the state, which is the relevant standard here on sufficiency review, it's entirely rational for a trier of fact to conclude that Mr. Arnold acted with premeditation here. Sort of specifically addressing some points made by my friend on the other side, there's a lot of discussion in this case of various sort of indicators of premeditation that are mentioned in Reynolds. And to some extent, Your Honors, I agree with my friend on the other side that some of the things discussed in Reynolds aren't really present in this case. And I think maybe where my friend on the other side has made a slight misstep in his argument is this attempt to almost reduce Reynolds to some sort of almost bean counting exercise, that to determine whether or not there's premeditation under Reynolds, we look at some factors, and we sort of count which Reynolds factors speak to premeditation and which ones don't, and whichever one is greater, that one wins. Your Honors, that's not been my understanding of the Reynolds case. Reynolds, in that case, the court held out as a non-exhaustive list. Essentially, all they say is, here are some things that speak to premeditation. The absence of those things doesn't speak to an absence of premeditation. It just means they're not present in a certain case. Here, the evidence I've pointed the court to earlier speaks strongly to premeditation. Some Reynolds factors certainly aren't present here, but that simply does not and should not affect how this court conducts its sufficiency analysis. Turning to the closing argument issue, Judge Ayers, you asked several questions of opposing counsel about what happened at trial. And precisely what happened is the prosecutor makes this statement, page 645 of the record, that where he recounts or attempts to recount some words that Mr. Arnold said during a traffic stop. There is an immediate objection by Mr. Arnold's trial counsel. There is an immediate curative instruction given by the trial court, and it's the instruction Your Honors would expect. The sort of typical, arguments and statements of counsel aren't evidence. To the event, ladies and gentlemen of the jury, you find statements of counsel are inconsistent with the evidence, disregard the statement of counsel and look towards the evidence.
When there's no evidence to the contrary, how's a jury? In other words, there's not really anything else. Well, I guess maybe the statement that was made through the Georgia officer was into evidence, but it's a little hard to counter that at that point.
Well, there's the statement of the Georgia officer, but there's also the video, Your Honor. Okay. There are, and there's a video exhibit of this traffic stop. It's a dash cam video. So
where he does say whatever he said.
He says, he doesn't say word for word what the prosecutor says, and that's the nature of the objection.
Sure.
But he says something along the line. He says a couple of things, but he does say, I went there to confront the victim and he pulled a knife on me, and then he says self-defense shit.
So his actual words were played to the jury.
Yes, absolutely.
Okay, that was my question.
So the jury can view him, can hear what he says, which is, I went to confront him, he pulled a knife, self-defense. That's really not that far off from what the prosecutor says. The prosecutor does say, I shot him in self-defense when he pulled a knife on me, but that's rather close in spirit to, I went to confront him, he pulled a knife on me, self-defense shit. Especially when considering that as soon as he's pulled over, the defendant readily identifies for his compatriots in this car and for the officer that he knows this is about whatever happened in Tennessee. The jury also hears him say that. That's all on video. So the jury can see his actual words and say, okay, prosecutor didn't get it exactly right. Trial judge is telling me I need to look at the defendant's actual words and follow that instruction. So when that instruction is given, Your Honor, there's no, any error such that there has been cured. Mr. Arnold's counsel doesn't ask for any further relief. He signals to the trial court, well, you've granted my objection, and I'm satisfied with the cure you've given me. He has to do more if he wants to get before this court on appeal with a preserved issue saying the trial court erred. He has to tell the trial court, I think you need to do more. I think an error has been made. I think what you've done isn't enough, and he hasn't done that. So I'd suggest the issue is waived and should be reserved for plain error, or should be reviewed solely for plain error. But really, Your Honors, my argument would be substantially the similar, or is going to be substantially the same under plenary or plain error. Largely going to focus on, I think a friend on the other side admits that there's no malintent on the part of this prosecutor. That's an important consideration under judge. I'd like to point to sort of the facts and circumstances of the case, and again point this court to how close the prosecutor's statement is to what the defendant says. There's certainly some difference, enough difference for the trial court to give a curative instruction, but it's not as if the prosecutor invents this idea out of whole cloth that the defendant has raised the idea of of self-defense. The defendant did that himself during this traffic stop. The jury did receive, Your Honors, they did receive a self-defense instruction at the request of the defendant. It's in the second volume of the technical record, contains the trial court's written instructions, and the self-defense instruction is included there. So we have the prosecutor sort of referencing this idea of self-defense that the defendant has brought up himself. Maybe he doesn't get it exactly right, but the trial court immediately remedies whatever error there is with the curative instruction. This simply isn't a case where any further cure is needed. And since that's what we're before this court talking about, essentially was the trial court's cure enough? In this case, it was, considering the sort of minor nature of whatever mischaracterization this is, the context of the case, and the immediate curative instruction. There's no need for this court to take the sort of extreme measure of reversing a conviction for improper closing argument, something the Tennessee Supreme Court has said should be reserved for only the most severely improper arguments. This is not one of those arguments, Your Honors. Unless there are any further questions, I'd ask that you affirm.
It just seems a little improper to me to say the defendant said he killed a person when the defendant never said he killed a person.
And perhaps minorly so, Your Honor. And I think, Your Honor, the trial court might have thought the same, and that's why it gave a curative instruction. But I do want to, I think I do want to sort of look to the intent of what the prosecutor's saying here. He does, include this sort of specific phrase like, I shot him in self-defense, whereas the defendant just says self-defense. There's some difference there, but really I think the key idea that the defendant is saying on this video that the jury hears is, I went to confront him, he pulled a knife, and I acted in self-defense. That's just about what the defendant is trying to convey to the cop when he's being arrested. The jury hears him say that. The prosecutor says, I shot him in self-defense. The delta between what's said on the video and what is said at closing argument is pretty small. It'd be a much more concerning case if we didn't have the video, if we didn't have the defendant saying, I went to confront him, he pulled a knife, self-defense. We'd be playing a different ball game. But here, we have him saying something substantially similar to what's said at closing argument, and we have the benefit of a trial judge who's a trial attorney for Mr. Arnold, and a trial judge who act quickly to remedy whatever error they see. If there are no further questions, I'd ask that you affirm. Thank you, Your Honors.
Thank you. Mr. White, rebuttal.
Your Honors, this is not a semantics issue. This is an issue of a prosecutor supplanting words into the defendant that the defendant did not say, or that the appellant did not say in this case. My client's due process rights were violated right then and there when he used his constitutional right to remain silent, did not testify, and then the prosecutor gets up there and says, hey, he said this, when he didn't say it. I think a ruling in the state's favor on this, Your Honors, I think that could create a chilling effect. The right against self-incrimination is God-given and to the core. And if we allow prosecutors to rephrase statements of the defendant, I think that leads to a very slippery track. Are we saying that, yeah, as long as the judge throws that out there, that, hey, that's not evidence, let's move on, then where does it stop? At what point can the prosecutor jumble up enough words to where, oh, yeah, well, he really meant that when he said this?
Wouldn't you agree it would be a little different if the video of his actual words were not in the record for the jury to see and consider, along with the trial judge's curative instruction that, hey, arguments aren't there, are not evidence, and if what the prosecutor said doesn't meet with the evidence, and juries are presumed to follow instructions. So don't you think it's a little bit different since we have his actual words here?
Well, the actual words still don't, Your Honor, equate to I shot Bill Jones. Your Honor, it's a pleasure to be in front of you. Thank you so much for your time.
Thank you, Counsel. Counsel. All right, call the next case, please.